On January 11, 2026, in a Michigan district court, Judge Kristen Simmons presided over an eviction case between St. Joseph Properties and defendant Stephen Rutherford, doing business as Car Audio Accessories, LLC. The case, numbered 26W0102, involved $2,610 in unpaid rent plus court costs. Rather than proceeding to trial, both parties appeared with legal counsel to present the court with a negotiated settlement, demonstrating how landlord-tenant disputes often resolve through agreement rather than adversarial litigation.
This is the matter of St. Joseph Properties versus Stephen Rutherford and Car Audio Accessories 26-00102.
Good morning, Your Honor. I'm David Brake, and I represent the plaintiff in this matter, St. Joseph Properties. The defendant is represented by legal counsel. I believe she might be on Zoom. I don't know if you have a waiting room that maybe she's there. Her name is Deanna Waller-Bundy.
Ms. Waller-Bundy. Okay, can I have your appearance for the record, please?
Deanna Waller-Bundy, appearing on behalf of the defendant.
Defendant whom?
Stephen Randolph. I'm sorry, 1 second here. Stephen Rutherford. Please excuse me. And Car Audio Accessories, LLC.
Okay, you're representing Car Audio as well. Okay. Okay.
Yes.
Today was the date scheduled for a hearing for non-payment of rent. How are we proceeding?
Your Honor,
go ahead.
If I may, we've reached an agreement on this and have entered into a consent order for conditional dismissal that has been submitted to the court. I don't know if I made it to the court's file yet. It was submitted yesterday afternoon. But if not, we can recite things on the record. I believe that my client is also, he's probably in your waiting room as well. His name is David Dayton. He's the owner of St. Joseph Properties.
You can put the terms on the record.
Very good, Your Honor. So we have agreed to conditionally dismiss the matter with the defendants paying on or before March 11th, 2026, the rent that's owing through today's date of $2,610 and the court costs of $192.32 for the total amount of $2,802.32. If the defendants do not pay this amount by March 11th, 2026, the action will proceed without notice to the defendant or further process. The matter would be reinstated and a possessory judgment would enter for the amount of the rent that plus the court costs of $2,802.32. I believe those are the terms, Your Honor.
Thank you. Ms. Waller-Bundy, that's accurate?
Yes, Your Honor.
Okay, your client's been advised of their right to proceed to a trial in this matter?
Yes, he has.
Okay, he wishes to waive that?
Yes, he does.
Okay, pictures are on here. Partial performance will not satisfy this. So you got to pay the full amount on or before the date that you agree to. Otherwise, judgment can enter against the defendants without any further court hearing. Okay? Do you have any questions about that?
No, Your Honor.
Okay.
The parties presented a consent order for conditional dismissal, converting what would have been an eviction trial into a negotiated settlement with strict payment terms and automatic judgment provisions. Under Michigan Compiled Laws Section 600.5714, summary proceedings for possession allow parties to enter into consent judgments that modify the standard eviction timeline and procedures. The Michigan Supreme Court in McClellan v. Ricard, 1986, upheld the enforceability of conditional dismissal agreements in landlord-tenant cases, recognizing that stipulated judgments with reinstatement clauses serve judicial efficiency while preserving the parties' bargained-for rights. Michigan Court Rule 2.6002 further governs the entry of consent judgments, requiring that waivers of trial rights be knowing, voluntary, and intelligent. Here, defendant Rutherford, through counsel, explicitly waived his statutory right to a trial under Section 600.5714, what Judge Simmons confirmed by asking whether he had been advised of their right to proceed to a trial and whether he wishes to waive that. The conditional dismissal structure mirrors the McClellan framework. If Rutherford pays $2,802.32 by March 11, 2026, the case disappears. If not, judgment enters automatically, without notice to the defendant or further process. This eliminates the need for a second hearing while binding the defendant to strict compliance. Partial payment, as the judge warned, will not satisfy this conditional dismissals. Streamline court dockets but place enormous pressure on tenants to perform. The automatic judgment provision means a tenant who pays $2,800 and $2,800 and $2,800 and $2,032.32 still faces eviction and a money judgment. For viewers, this illustrates how settlement negotiations in eviction cases require careful attention to boilerplate language that can extinguish due process protections with a single missed deadline. Judge Simmons signed the consent order on January 11, 2026, making it an enforceable court judgment. Stephen Rutherford now has until March 11, 2026, exactly 59 days, to pay $2,802.32 in full. If he succeeds, the eviction case is dismissed and the public record reflects resolution without judgment against him. If he fails for any reason, including paying all but $2.32, a possessory judgment enters automatically. St. Joseph Properties gains the right to evict, and Rutherford owes the full amount plus potential additional costs. No second hearing. No further notice. The case ends either with a tenant who kept his housing or a landlord who gained possession without trial. This case exemplifies the tension between judicial efficiency and individual due process in America's eviction courts. The conditional dismissal mechanism, blessed by statute and case law, resolves approximately 70% of eviction filings nationwide before trial, preventing courtroom congestion, but often at significant cost, to tenants who may not fully comprehend what they signed. The without notice reinstatement clause that Judge Simmons enforced represents a contractual waiver of the fundamental right to be heard before losing one's home. Courts have consistently upheld such waivers under the reasoning that parties may contractually modify procedural rights, yet critics note the profound power imbalance between commercial landlords and individual tenants. For legal system observers, this case demonstrates why the right to counsel in housing court, currently guaranteed in only a handful of jurisdictions, matters profoundly. Rutherford had a lawyer who could explain the stakes, negotiate terms, and confirm his understanding. Tenants without representation frequently sign similar orders without grasping that a single missed payment transforms a dismissal into an eviction judgment that haunts their rental history for years. The law permits these agreements. Whether justice is served depends entirely on whether both parties entered them with genuine comprehension and meaningful choice. If you're facing eviction or any court proceeding, never sign a consent order without understanding every term, especially automatic judgment provisions and strict deadlines. If you cannot afford an attorney, contact your local legal aid society, tenant rights organization, or bar association referral service. Many jurisdictions offer free or low-cost representation for housing cases, and some courts provide self-help centers that explain settlement documents in plain language. Remember, a signature on a court order binds you more permanently than most contracts. Read carefully, ask questions, and know your rights before you waive them.